We're starting to live. Okay. Welcome to the afternoon session of the Kansas Court of Appeals. At this time, we'll be hearing case number 120816, State of Kansas versus Stephen Wayne Bird. Would the parties state their appearances, please?
May it please the court, the appellant, State of Kansas, appears by Stephen Obermeyer, an Assistant Solicitor General.
May it please the court, Mr. Bird appears through counsel Chris Joseph.
Okay. And Mr. Obermeyer, did you wish to reserve any time?
Yes, if I may reserve 8 minutes, please.
8 minutes it is. These are both, this is set for 20 minutes of argument, so. All right. I'm really bad at doing introductions of this new format here, but I am Chief Judge Karen Arlberger, the presiding judge in this case, which only means I get to keep time. And with me today is Judge Thomas Malone, former Chief Judge of our court, and Judge Richard Walker, senior judge with our court, who came on as a senior judge after being 31 years on the trial bench in the 9th Judicial District. So with that, we'll go ahead and get started. Mr. Obermeyer, you are the appellant cross appellee.
Thank you. May it please the court. My intent during my opening here is to talk about the main issue raised in the state's direct appeal concerning the dismissal of count 2, and then also address some of the validity of the defendant's cross appeal in this case. As the court recalls, this is the case where Stephen Wayne Bird was indicted with 2 felonies, aggravated indecent liberties with a child and aggravated indecent solicitation of a child. A week before trial, defense counsel filed a pleading captioned notice of defect in count 2 of the indictment, and it argued that count 2 was defective and void under State versus Bird, and that it failed to vest jurisdiction in the trial court because the indictment included the word knowingly in the indictment. So after the jury was selected but sent home on the first day of trial, the court took up the issue and after hearing the arguments of both sides, found that the addition of the word knowingly was problematic, and typically the court would have instructed on committing the crime knowingly, recklessly, and intentionally, and so this knowingly was a problem. And in addition, the court found that State versus Brown was applicable, and State versus Brown said that the crime of aggravated indecent solicitation of a child was a specific intent crime, and dismissed the case. So the state appeals that dismissal, and there are basically 4 arguments as far as why the dismissal was erroneous. The primary argument being that State versus Bird, which was cited three times in the notice of defect, had been overruled by State versus Dunn, and the Dunn court, it's a very lengthy opinion, but it overruled the line of cases that said any defect in the language of a complaint is a jurisdictional defect, and charging documents do not bestow or confer subject matter jurisdiction. The Kansas Constitution does, and the charging document need only show that the case has been filed in the correct court, the district court as opposed to the municipal court, that the court has territorial jurisdiction over the crime alleged, and if the alleged facts are proved beyond a reasonable doubt, it would constitute a crime. So that's the first reason that State versus Bird has been reversed. The second reason is KSA 223201 says that the indictment shall be a plain and concise written statement of the essential facts constituting a crime, which indictment drawn in the language of the statute shall be deemed sufficient. If the court compares the language of the statute with the count 2 of the indictment, the court will find that it's pretty similar, the only difference being the addition of the word knowingly. So what about the knowingly part? And for that, I cited State versus Vacas to argue that if it's not applicable, it can be disregarded in the jury instruction conference, certainly. In the Vacas case, the word legitimate was added to the indictment, and the court there said, while it's true the word legitimate is not contained in the statute, we believe that its use in the indictment does not change the elements of the crime, doesn't charge a different crime, doesn't fail to state a crime, nor lessens the state burden of proof. So I would liken this case to the Vacas case if the court deems that aggravated indecent solicitation of a child is a specific intent crime. But the fourth point in the opening brief sets out several reasons why the law has changed since the State versus Brown. The main change is that there's been a recodification of the criminal code, and no longer did, or whether it was a specific intent crime or not, because we have the statute 215202, which sets out different levels of intent. And if the statute says with intent or intentionally in it, then it's a specific intent crime, unless there's some other culpability requirement in the statute. And if you look at the aggravated indecent solicitation of a child statute, it's 215508B1. It is enticing, commanding, inviting, persuading a child under the age of 14 to commit or submit to an unlawful sexual act. It no longer contains the word solicitation in it, which the old statute under KSA 213511 included. And we know that solicitation is a specific intent crime under Kansas law. So it no longer has that. So Brown is really questionable whether it's still applicable because of the new criminal code and basically 215508. The state's position is that subsection E applies and that the jury would have been instructed on all three culpable intents or means.
Mr. Obermeyer?
Yes.
On the current wording of 5508B, it currently says aggravated indecent solicitation of a child is enticing, commanding, inviting, persuading, or attempting to persuade. And you're saying before it included solicitation as one of those listed items, and now that's not there?
Correct. It previously said it's enticing or soliciting a child under the age of 14 to commit or submit to an unlawful sexual act.
Thank you.
Yes, okay. So, and then the other case the court relied on was an unpublished case of Richardson. And in that case, the defendant argued that aggravated indecent solicitation, that the jury should have been instructed that he intended to perform the act of enticing or soliciting the child. And this came up in an ineffective assistance of counsel action. And the court there said that the specific intent requirement is a requirement that the other person, in this case, the child, commit or submit to an unlawful sexual act. There's no requirement in KSA 213511 that the offender intend to commit the unlawful sexual act with the child, just that the offender intends to solicit or entice the child. And the court there said that the district court didn't err in finding that counsel was not ineffective for requesting an instruction concerning a specific intent to perform the act of soliciting or enticing.
Okay, I'm sorry, Mr. Obermeyer, and I'm probably just showing my own ignorance here, but so is it your argument, since the word solicit is not listed in that statute anymore, that it's now a general intent and not a specific intent crime?
Yes.
Okay.
And yes.
I get it now. Okay.
And if you look at the pattern instruction, which is Pick Crim 4th 55.160, there are two option ones as far as how the crime could be committed. The second option says the defendant with the intent to commit, enticed and commanded. The option that would have been instructed in this case is the first option, and the notes on use say that one or more of the alternatives waives as committing the crime lacks a required culpable mental state. If applicable, look at Pick 52.300, which is the instruction that says you can find the defendant acted recklessly, knowingly, or intentionally. And that's how I think the trial court said she was initially going to instruct the jury on that. So.
Can I go back to an earlier issue that, frankly, I've been trying to wrap my head around and find curious, and that is as I read things, I don't think the defendant ever sought a dismissal of the count 2, but the judge kind of granted it on her own say-so. She kind of said, well, I think the defendant got a raw deal, so I'm going to dismiss count 2. So even though I don't know that was the tenor of the motion. Is that a fair summary or not?
The motion just says notice of defect in count 2.
Right.
At the end, it requests, it says count 2 cannot be submitted to the jury because it's void and fails to vest jurisdiction. So that kind of sounds like a motion to dismiss to me in sheep's clothing of notice of defect. And that's what the court, in fact, did, was dismiss the case. It looks like I'm out of time for my, oh no, I guess I have another.
1 minute.
1 minute. On the cross appeal, as I was going through the brief, I looked at where the defendant, page 18 of their opening brief, says, we asked the court to reverse the court's denial of his motion to dismiss because of the indictment. And he cites volume 1, page 156. So I look at that. Volume 1, page 156 is the defendant's motion to dismiss. There was no ruling by the trial court on this issue. She took it under advisement a week before trial because she wanted to write an opinion on the issue. And the state filed its response on the first day of trial. I know there's a recent case that says judges shouldn't be sleeping during trial or probably writing opinions. So she didn't have time to write an opinion that day. And at the end of the day, she dismissed count 2 and did not address the issue raised in the defendant's motion to dismiss. So this issue has not been ruled on by the district court. And our argument is the district court should have the first shot at that ruling. I see I'm out of time as to the first half, so I will sit down unless the court has any questions.
No. Thank you.
Thank you.
Mr. Joseph.
Thank you, Judge. I want to start with really the threshold issue, which is jurisdiction. Can we even proceed on this appeal? Shawnee County is unique. In Shawnee County, whenever there's a sheriff's department investigation, they elect to proceed by indictment instead of having a preliminary hearing. And their method of doing this is described, that's the subject of the cross appeal, but they are proceeding with a representative of the sheriff's department, essentially telling the jury, here's what the report said, I don't know anything. And when you elect to do this, whatever their motive may be for doing this, but they elect to go down this path of grand jury. And when you do that, you're stuck with grand jury rules. And this is one of those tricks that I think they caught themselves up in by picking the grand jury path. 22-30-15. That's the only mechanism for which you can make any substantive changes to an indictment. You can do it for non-substantive matters related to form, time, place, or names. You can do that without going back to the grand jury under subsection A. B provides the only exception, the one exception for when you can make a substantive change, such as dismissing count 1, and that is for the limited purpose of effecting a change of plea. This change, I ironically, was made at the behest of the Shawnee County District Attorney's Office. And in fact, the prosecutor of Mr. Byrd's case is the one that testified in support of this. So he is well aware that you cannot dismiss count one. Mr. Obermeyer points out that I was a little flustered when he came in the morning and said, I'm dismissing to appeal. And I spoke of whether or not it should be with prejudice or not. The reality is it was kind of a last minute dismissal after the jury selected, moments before we swear him in and present evidence. Having thought about it and the state not having made any reliance upon it, it occurred to me that that was ineffective. He couldn't do that. By statute, he cannot dismiss count one. If it was an information, if it was a complaint, sure. But because they chose to go down this path of indictment, the only way he can dismiss, the only way he can make any substantive change is 22-30-15, and that requires him to go back to the grand jury unless it's for the limited purpose of effecting a plea. As a result, his dismissal, if you will, at the time, the second day of trial, didn't happen. I mean, it was ineffective. It did not exist. So
I'm not following how a dismissal is a substantive change. He didn't try to change count one. He just dismissed it.
It is a substantive change.
I don't see why that's barred by the specific statute that you're referring to.
So first of all, there's a discussion in the unpublished case we talked about is what is a dismissal and what is the authority for it. There's no statute out there that says you can dismiss. So in that case, it wasn't this panel, but the Court of Appeals said, hey, let's look at this statute because that's the only one that exists. You can go look for complaints and informations the prosecutor controls. You can go look at the statute for that. But for indictments, the only, an amendment, a dismissal is a substantive amendment. In fact, if you read through our brief, you look at the history, the whole point is the grand jury is to control. If it's an investigative body, it's directing the prosecutor to go prosecute these crimes. Once a grand jury indicts, the prosecutor's role is to go prosecute that. He can't say, no, I don't agree. I'm just not going to do it anymore. That's not the authority. That's not
You're
what
saying a prosecutor can never dismiss an indictment. Move to dismiss.
Correct. The only way a prosecutor can dismiss an indictment is part of effecting a change of plea by the defendant pursuant to a plea agreement. The theory being is if it is initiated by grand jury, the grand jury controls.
Mm-hmm.
I mean, if it's initiated by complaint or information, the prosecutor controls the course of litigation. That's the whole theory behind grand juries. If you're using
you're saying their only alternative was get a superseding indictment then?
Absolutely. And in fact, that's why I filed the notice, the document entitled notice. I didn't file a motion to dismiss. I remember that vividly. When we're getting ready for jury instructions, kind of had the aha moment of, wait, they stuck the wrong intent element in there. By the way, it's not reckless, knowing, or intentional. It's only intentional that can make any sense. When we came across that, we said, oh, well, Matt's going to need to file a superseding indictment. I'm going to go ahead and send him an email. But just to be clear, I'm also going to file this document saying, hey, this is a big deal, Judge. You need to be aware. He needs to go back to the grand jury. And that's why he talks in the record about we do have a sitting grand jury. We may go back and fix this. The choice not to do that is what put Judge Paris in a really difficult predicament. And that is because you cannot recklessly entice or command a child to engage in a sexual activity. You can't knowingly do it either. You can only intentionally do that. They picked a lower intent. So probable cause was found on a lesser intent than what is required by the statute. It is a red herring to say that the court relied on the old Byrd case or did not consider Dunn. What happened is we are here after the jury's been picked. And simply because there was a snowstorm, they were not sworn in and double jeopardy did not attach. But here we are. And the judge decided to use some of the time to take this up and ask Mr. Patterson, hey, why didn't you fix this? What are we doing now? I've got a probable cause finding based on something less than what's required for this crime. What do we do? I hadn't specifically said, let's get rid of this, let's dismiss it, but we hadn't gotten there. The point is, think of it like a preliminary hearing. If the evidence presented at preliminary hearing showed only knowledge, not intentional act, a lower intent element, and then they want to say, oh, that's wrong. I'm going to file an amended information to raise the level, to make the elements correct, the intentional act. I'd get a new prelim because they haven't shown probable cause for the crime charge. They've showed probable cause for something less, right? And that's why, because they chose to go to grand jury, he needed to go back to the grand jury and show probable cause for intentional conduct. I mean, again, you can't recklessly entice or command a child to do something. You can't knowingly do it. I mean, what does that look like? If I act a certain way, I know the natural inevitable result will be that they're enticed. I mean, that's strange. It has to be intentional. So the appropriate jury instruction would have been only to instruct on intentional conduct, not lesser ones. And so we're left with,
on this issue, under the current statutory language, what is your argument that aggravated indecent solicitation is a specific intent crime?
well, again, the recodification, I agree, shifted away from specific and general intent. What we're now talking about is whether or not it's intentional, knowing, or reckless. Specific intent crimes are, unless it's with a specific intent to do something, are intentionally acting. The general intent crimes are knowingly, just kind of the natural consequence. So under B, there are three, I'm looking at 5202, there's three types of mental states available, and you have to instruct on the one that is applicable. Sometimes all three of them are going to be applicable. But in the case of aggravated indecent solicitations, I mean, just think for common sense for a second. How does one recklessly entice, command, invite, or persuade?
What word in 5508B1 tells us that this is intentional but not knowing?
You have three options for which you can instruct. You can instruct on all three if all three apply, or you instruct on only one if only one applies. And if you looked at what they mean, H, I, and J, one cannot consciously disregard the risk that they're going to cause a child. I mean, it doesn't even make any sense. Knowingly doesn't make any sense. The only one that could fit when you're enticing, persuading, or commanding a child to commit a specific sexual crime is intentional conduct. And that's why it used to be considered a specific intent crime, and post recodification, it is an intentional crime. You can't recklessly or knowingly do it. Only intentional applies, and therefore the instruction, I mean, if you look at the PIC, it says instruct intentional, knowingly, or recklessly. There's or between them, or all three. And the only one that fits that crime is just fairly direct and simple. The only one that fits is intentionally. If you were to instruct that you could recklessly commit this crime, I think that would be a real problem. And I know, Judge, the initial part of her kind of rambling description of what remedy am I going to fashion? What am I going to do with this? The fact that the state put knowing in there. What do I do with that? She mentions I would have instructed in all three. I didn't get the chance, and because she ended up saying I'll dismiss, I didn't get the chance to say no, you should only do intentional. That's the only one that makes sense, because she reached what I think is the right result. Is you have a probable cause finding based on knowing conduct, which I guess means being aware with respect to the nature of such persons or conduct, just aware of the conduct or circumstances exist. How does one knowingly entice, command, persuade, or invite? It just doesn't make sense. So only intentional works.
Do you agree that your notice of defect, or whatever the exact caption was in effect a motion to dismiss in different clothing?
I think ultimately that was the only remedy that was available when they chose not to supersede. So, I mean,
why did you just file a motion to dismiss because of that defect?
Because I wanted to tell the prosecutor he can go supersede, and he's got a problem. And you know, I mean,
a motion to dismiss would have given him the same hint.
Perhaps. I mean, what I thought about, on one hand, I could have simply, I mean, we're past the motions deadline. What do I do with this? Do I just wait for the instruction conference, and then at the last minute say, it's all screwed up, you can't send this to jury because they picked the wrong word. It literally, as we're getting ready for jury instructions, got to figure out what to do. This is not part of the motions. I mean, we've already litigated motions. We've had a Gregg evaluation. We've had all sorts of things down the road. I'm trying to be fair and not sandbag the state. So I wanted to explain ahead of time, here's what's happening. I just saw this. I want to put everybody on notice. So when we get to the jury instruction phase, when we deal with this problem, I'm going to say you can't submit this to the jury because probable cause was based on something less than what is required. And so, I mean, sure, I could have called it a motion to dismiss, but that would have created other issues. Mr. Obermeyer would just be saying that I filed a motion too late. I'm genuinely trying to be fair to the prosecution at this point, to put them on notice that there's something amiss. I don't think anybody realized it. In fact, I didn't notice it until we're doing jury instructions and looking at elements, and then, that one word pops right out. And it's a really big word because it changes the intent requirement. It's a lesser intent requirement, and for which I think I get a probable cause finding before you can submit the case to a jury and expose the client to, or the defendant to, the jeopardy associated with a full jury trial. I think I need a probable cause finding on that. Now, one other thing amazingly, I've used most of my time. So before I wrap up, I do want to talk about the cross appeal. This to me is a problem. And this is the first time, at least, that I've brought this in front of the Court of Appeals, any Court of Appeals. I'm not aware that anyone has. This is a true attempt to turn the grand jury into a rubber stamp mechanism. Now, I understand Mr. Obermeyer makes a point. To this day, I remember Judge ruling. I don't know where that written decision is. We can't find it in the record. As far as the record is concerned, it doesn't exist. So what happened? I remember it, but it apparently didn't happen according to the record. So we are in one of these situations where we'll assume there's no explicit ruling on the motion, denying the motion. There is clearly an implicit decision denying the motion, because you don't start a jury trial on a motion not to proceed to jury trial. It is a ruling. It is an implicit ruling, unlike the Vacas, I think V-A-K-S, Vacas case or Vacas case that Mr. Obermeyer points to. In that case, they didn't reach a ruling on a request for sanctions because it was dismissed. Here, we went to trial. We picked a jury. We're about to present evidence when the state dismissed. Implicitly, necessarily, she has denied my motion at that point, making it ripe for a ruling. Furthermore, this clearly meets one of the two exceptions. There are no disputed facts. We submitted this on kind of a stipulation. Here's how it works in Shawnee County. We want this to be reviewed because it's appropriate for review. All they're doing is presenting to a grand jury. This is the definition of rubber stamping, turning what should be an investigative body, which should be a body in control of just making them a rubber stamp. We're getting rid of prelims. We're not having any meaningful probable cause determination. We have some guy who has nothing to do with any of the cases that goes and reads reports and repeats them to a grand jury. That's all they present. I mean, why have a grand jury? Why have we're just going to skip the probable cause determination and why not just hand them the reports? I mean, if it's a rubber stamp, it is not a meaningful review of probable cause. Now, much like their problem with dismissal, when statute doesn't let you just make a substantive change without going back to the grand jury, they have a problem here. And that problem is not one of constitutional origin. This is not about this, federal courts and whether or not there's a constitutional violation. This is, what does the statute allow a grand jury to consider? And by statute, and we can talk about a Turner case briefly, it's a little different factually in the sense that some extraneous information about an attempted murder, really scandalous case, by the way, it was presented to the grand jury and tainted the real legal admissible evidence. Here we have no legal evidence, no admissible evidence. We have second and third hand hearsay only. And that's it. Cop goes in there and says, I read this report and here's what it says. You should charge this guy. And they say, okay, that's not probable cause. That's a rubber stamp. That's just the
Have you checked? Have you checked to see whether any ham sandwiches have been indicted in Shawnee County?
I think Mr. Byrd may be a ham sandwich, but yeah. I mean, the way they are doing this, the current administration essentially said, hey, I found a way not to have my witnesses cross-examined with his regular old prelim. So let's just go ahead and ram them all through. And the judges aren't happy about it. You saw Judge Parrish comment on about it, but yet they didn't grant the motion. So here we are. It is a problem. They have undercut the preliminary hearing. And again, we're not talking about constitutional issues. We're not talking about federal court, because federal, very different. In federal court, you can dismiss an indictment with cause. There's all sorts of different rules there. And we're not even talking about federal review of the New York courts, that rule 603 or 609 letter that was filed. That's not it. And this is the point. The point is, what is the statutory intent and the framework for Kansas grand juries? And that is, these grand juries are are created. Let me make sure I'm getting the language right. Are created. They're created and impaneled under the supervision of the court. Rules of evidence apply to all conduct, quote, under the supervision of the court. That language literally lines up. We're talking about 60-402 lining up with in re order of summons to grand jury, a Kansas Supreme Court case. It's impaneled under the supervision of a court. Rules apply to conduct under the supervision of a court. That's the statutory framework. And in Turner, they go further. The Supreme Court says, yeah, that's right. A grand jury can base an indictment solely on legal evidence. And again, there was some conjecture and some prejudicial, inadmissible evidence before Turner, but even in Turner, there was some legal evidence presented. So in this case, it's even worse. No legal evidence was presented to a jury. Just, I read this report and here's what it said. Somebody told me, told you. So please indict. So it is akin to indicting the ham sandwich. It is a problem. And it is not a moot point, because the state is asking you to return this charge back to the district court to prosecute this very charge, count 2. I mean, assuming count 1 is actually dismissed. I don't think it is. I think count 1 is still sitting there, and as a matter of black letter law, you can't split off a case, appeal 1 while there's still something pending in district court. By statute, I don't think you could have amended / dismissed. That's the same thing, the grand jury indictment. They don't get to dismiss for any reason other than what is permitted by statute, which is solely to allow a change of plea pursuant to a plea agreement. If they think it needs to be different, they can go back to the legislature.
You're at the end of your time. Any more questions from the panel for Mr. Joseph? Okay, you have 8 minutes, Mr. Obermeyer.
Thank you. I just have a couple of points to say. Let's say on the day that the motion to the notice of defect is being considered, and the state says, you know what, I agree with defense counsel, it should be dismissed. Under his argument, the state has to go to the grand jury, if it's still in session even, and ask for what? Not a superseding indictment. We think the case count should be dismissed because of a notice of defect. So what is the grand jury, what are they supposed to do with that information? That's not a remedy. The grand jury statute is there because it's one of 3 ways that a prosecution can be initiated: by indictment, complaint, or information. And it says nothing about how a prosecution can be terminated, because that's a prosecutorial function. What if there are witness problems with the indictment? You don't have a witness. The state has to fly the plane into the mountain because, well, we need to get the grand jury's approval to dismiss this. What if there's evidence suppressed by the court? The state can't dismiss. It has to go to trial because the grand jury indicted. What about the sufficiency of evidence? Because if there's an issue with that, and there is several grand juries in Johnson County several years ago about a statue at the Overland Park Arboretum where they were trying to say that's obscene. What if there was an indictment and the state disagreed that that's not obscene, it's a statue? the state has to try that case. I don't think that that's the case.
Mr. Obermeyer, what do you have to say about this argument that the grand jury procedure is defective? Do you have that this idea of just having a police officer who goes and reads the reports on another case and comes in and says, yeah, this is what happened. I've read the reports. How is that a proper procedure?
I would say that certainly that Turner doesn't apply, that KSA 223003 tells the jury that you shall inquire into offenses of which you have or can obtain legal evidence. So if you
How
can
is that
obtain,
legal evidence?
well, what if that person testified at trial without an objection? It's evidence.
But who's there to object at the grand jury? There is no representation for the defendant. There's
And
nobody to
sometimes-
object.
I'm sorry. And sometimes the prosecutor's not even there. So the
Right.
grand jury has to guess, well, is this going to be admissible or not admissible as evidence? And if you look at 6460D, contemporaneous admissions, you need a finding by a judge that it's reliable. So we got to bring a judge in to preside over the grand jury to bring this in. And I just rely on that and also the arguments in the brief concerning that. As to the dismissal of count one, the judge ordered it was dismissed, just like the judge ordered count two was dismissed. How is that not a dismissal? And defense counsel says, yeah, I agree, the state can do that at the time of trial. And I know we researched it in like 30 minutes, but this is a very convoluted argument as to, no, it wasn't really a dismissal, it's still pending. About the indictment and whether it's a lower standard of conduct, I would direct the court to the State versus Boschling case. It's at 311 Kansas 124. It's cited in the second state's brief. And there, the defendant was charged with knowingly committing a burglary. And the court said, well, that's a specific intent crime. But the defendant really got a benefit because the state had to prove that it was an intent to commit a burglary and that it was knowing. So that was an assist for the state. The same way here. If whatever language, and I didn't hear the answer to where the specific intent was in the statute, wherever it comes from, the state proved that and it proved knowingly. So just like the Boschling case, everything was met. And again, there's no language in that statute that deals with intentional conduct. So I think the jury could have been instructed on knowing or intentional in that regard. As far as the remedy, the court applied Byrd and dismissed the case because of the court deemed that it wasn't it was void. The court kind of had second thoughts about it the next day and said, well, why don't I reconsider that and revisit that? Because maybe it's something that can be addressed at the jury instruction conference. So I think that kind of militates against that. I think it's void, or that the court had to dismiss it. That is an issue that could have been addressed at the jury instruction conference.
It appears that Judge Parrish was begging for some opportunity to get some good legal research done on this before she made a decision, because she kept saying, look, give me a reason to reconsider this. I mean, I'll be happy to do that. Right. Well, and it sounded like the state had filed a motion, but then withdrew it because I think it had concerns about, can we reinstate a dismissed count? Right. Just like, count one, was it really dismissed? I mean, who knows what arguments are going to come up later down the road. The jury sitting there. Right. And I don't think that dismissing a count is an amendment of the count, that the state can do that. And that it's not an implied ruling. The judge still could have dismissed that case after it proceeded to jury trial. She specifically said, I want to take this, I want to write an opinion and take this under
under advisement. And it's different from a motion to suppress under advisement and the evidence comes in at trial and the defendant's found guilty. I get that. But where if the jury had come back guilty, the judge still had a motion to dismiss based on the grand jury procedure that she wanted to write an opinion on. She wasn't allowed, she didn't have an opportunity to do that because the motion was filed shortly before trial, the motion to dismiss. And she wanted to write an opinion. And so I don't know what the ruling would have been, how it can be analyzed on appeal, and that it really can't be, it's basically an advisory opinion at this point because there's been no ruling by the trial court. And no matter how interesting it may be, this court does not issue advisory opinions. And it was the only issue raised in the cross appeal. So there's, if you don't have jurisdiction to go with that, then it can't be an issue considered or raised for the first time on a cross appeal. The caption of the notice of defect, I would just note that the defendant filed a motion to dismiss on January 8th of 2019. And then 6 days later, the notice of defect was filed on January 14th. So it clearly could have been captioned motion to dismiss. And that kind of triggers, okay, well, now the state has 21 days to file a response and address that. So
You're about out of time.
I am. So for all those reasons as set forth in the brief and as we discussed today, the state would ask the court to reverse the dismissal of count 2. Thank you.
Any questions for Mr. Obermeyer? Okay, thank you all very much. We'll take this matter under advisement and issue an opinion as quickly as possible.
Thank you.